Mr. Ingleson, we're just trying to get a hold of the other party's attorney, Mr. O'Keefe. Can you just hold on the line for a little bit?
Certainly, Your Honor. Good morning.
Okay, good morning. Thank you. Okay, Mr. Ingleson, are you able to hear me okay?
I am, Your Honor, yes.
Thank you. We'll go on the record in Van Wormer versus Trozak. This is Emmet County file number 241085553. The court is sitting in this matter by assignment. We have present on behalf of the plaintiffs, Van Wormer, Mr. Ingleson. This hearing was set for 11 a.m. It is now 11:15. The defendant or defendant's counsel has not appeared. The court has tried. First of all, the court did confirm that they're not physically present at the courthouse in Petoskey by mistake. The court also reached out to Mr. O'Keefe's office to find out the reason why he has not signed in or appeared. As far as I know, no one has been able to contact Mr. O'Keefe. I instructed court staff to let him know that he needed to sign on by 11:15. So we're here today, number one, for defendant's motion to set aside a default, which based on their failure to appear here and the fact that the default was premised on defendant's failure to appear, the court is going to deny that motion. And then this was also set for a status conference. So given Mr. Ingleson that the motion to set aside the default has been denied, and your complaint, after having reviewed that, sought injunctive relief, which the court has granted by way temporarily of a preliminary injunction, and declaratory relief, how do you want to go forward so that I can get a final order and get this case wrapped up?
Right. Well, we, as the court's aware, secured a HVAC or electrician, I guess it was, I'm not quite sure what, and got a new gas line put on the outside of the building and then drilled through their end of the property into, and were able to connect their furnaces during that, if you will, emergent time frame in mid-November, at the time we filed suit and sought the ex parte order. That was at considerable expense, number one. Number two, they've spent a considerable amount of money with legal fees. So my goal would be to request a default judgment, ask for obviously a permanent injunction continuing so that they not interfere again. And number one, number two, and ask the court to consider the monetary damage affiliated with what occurred last year.
Okay, so in my view, you know, the cost of installing the new line, I mean, that's a sum certain, right?
It is.
Okay, are you asking for damages above or beyond that sum certain?
Well, number one is that. Number two is our costs and fees. The third item that my client has mentioned to me was the interruption of their work that affiliated with completing a restaurant that they were building in the lower portion of the building. And he, Mr. Van Wormer, also has a full-time employee they have a lot of real estate matters that engaged a lot of time during that time period to facilitate getting the electric installed and being careful in terms of the business. So that is a number I don't know specifically.
Okay. So I think if we were just dealing with the sum certain, then the court would, you know, I could enter a default judgment without a hearing. But to the extent that it sounds like you're going to seek other damages, so I think I would need to have an evidentiary hearing to determine the amount of damages now that, you know, liability is established. I think in terms of the declaratory judgment, the preliminary injunction, I don't think we need a hearing for that. I think you're entitled to that relief by virtue of the default. And you're entitled to a finding of liability for damages. And then I guess what would be left with is the amount. So I'm going to ask that you contact my assistant, request an evidentiary hearing for the default judgment. I don't know how much time do you think you would need to present proofs on those issues?
In a hearing?
Yeah,
Oh, an hour at most. I will
okay,
also
so just,
see on the, oh, go ahead, I'm sorry, Aaron.
I was gonna say, just to be safe, when you call to ask for the date, ask for 2 hours. That way we
All right.
we don't need all that time, that's fine.
Fine. I would also say on the record, I'm going to talk with my client, and my inclination would be for him to have us apply for some certain default judgment and not pursue the argument where you have to present proofs and have cross-examination and all that kind of stuff. But
Okay.
so I will contact your assistant as directed and let her know our direction. For certain, if it's that direction, we get a hearing date. Does that work?
Okay. Yep, and if you're not gonna be requesting damages outside of that, the cost of that, running that line, which is a sum certain, then with the judgment, I'll ask that you include the language that it's a final order that closes the case so that we can have it wrapped up. Otherwise, we'll deal with that at the hearing. The only other thing that I'll specify, if we do have that hearing, because it's an evidentiary hearing pursuant to the court rules, I will plan on conducting that in person in Emmet County at the courthouse there.
Okay, very good.
And I'll direct Jennifer to make sure that that gets set as an in-person hearing with the court in Tuscany.
Okay.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
All right. Thank you, Your Honor.